Again, my name is Adam Devine. Jason Lewis is here as well. We're attorneys with Chartwell Law, working out of I work out of the New York City office. Jason works out of the White Plains office. We're going to get started here in just one moment. I would just ask that everyone not use the raise hand function or the chat box. If you have any questions, we would encourage you to use the Q&A function at the bottom of your screens. And there will be several points where Jason and I are handing off the presentation. So we'll take a second to answer any questions that you may have at that point. So if you just put them in that Q&A, we'll get to those as soon as we hand off the slides. We're just going to give it one more moment, one more minute before we kick into the presentation.
We'll get started soon. As Adam mentioned, there's a few boxes on the bottom of the screen. If you have any questions while we're going along, it's the Q&A. I'll be looking at them while Adam's speaking, and then whenever he's done with his portion of the presentation, we'll go over some of your questions and then continue from there. Ready for the slides, Adam?
Yeah, why don't we go ahead and get started here? Okay, again, Adam Devine, Jason Lewis, thanks for coming. We're just going to go over the basics of New York workers' comp. If we don't cover something that if it's for another state, we're not going to be covering any of that information, but feel free to pop something in the Q&A and somebody will follow up with you afterwards. So New York workers' comp, it's the mechanism for which cash wage benefits are given to employees who suffer work-related injuries. The big thing is that in New York and in most workers' comp jurisdictions, negligence and fault are not something that the claimants have to prove. They just have to show that they got hurt at work. They don't have to show that their employers were negligent in any possible way. What that does is that it removes the ability to sue your employer for negligence, but lowers the bar for recovery. So you have a smaller chance of recovery in the monetary sense. The damages are less, but you much lower bar to clear to actually get those benefits recouped. The workers' compensation scheme does not remove third-party suits, which are suits where the claimant is hurt by somebody who is not their employer. Usually somebody else at a work site. Often happens with drivers who are in a motor vehicle accident while driving for their job. There'll be a third-party suit. And any payments that are made for indemnity and medical benefits by the workers' compensation carrier would be recoverable as a lien against any third-party awards that the claimant may have in that third-party suit. The two cases you may hear Kelly and Burns referred to as the lien recovery cases that govern how that happens. So if anybody mentions Kelly or Burns, they're just talking about recovery of liens against a third-party recovery from a claimant. So how does the whole thing get kicked off? There are two different ways that a claimant can make a claim for work-related injuries. They can have an accident or they can have an occupational disease. Accidents are by far the more common. And you may hear these referred to as ANCR and ODNCR, which is just accident notice causal relationship, or occupational disease notice causal relationship, which are just the things that a claimant has to show in order to have a compensable claim. So accident is more common. It just means that you have some unfortunate happenstance at work that results in an injury. Within 30 days, the claimant is supposed to give notice of the injury to their employer. It can be written, it can be oral, or it could be that it was witnessed by a bunch of people and the employer knows that it happened because they would be incompetent not to know that it happened. And the important thing is it has to be something that is in excess of just like regular first aid treatment. So if I cut my finger on a piece of paper here in the office, that's not going to be a compensable claim. I put a Band-Aid on it. But if it's something that requires me to go to a hospital or requires first responders or requires me to go to City MD afterwards, that would be something that would be compensable. For an occupational disease, that's something that is a injury that I suffer as a as the course of my employment. So we see this often with people who work in heavy lifting jobs, like warehouse workers who lift boxes often, and they develop degenerative disease in their shoulders or their back. And they can then make a claim for an occupational disease. The important thing to know about the occupational disease is that they have to file the claim within 2 years of knowing that they had a worker-related disability, or they should have known. So if a doctor tells them that their back injury is a result of repetitive lifting, and then they wait 2 years, that's could be a bar to having that claim. And then the typical way that the claimants file their claim, they start their initiation of the process is filing what's called a C3 form. And that just lays out the basics, where they got hurt, what happened, are they claiming occupational disease or an accident, what their wages were, those sorts of things are on a C3. Okay, eClaims. So this is what happens when the employer or the carrier has become, or the third-party administrator has become aware that there's been an accident or an OD claim. The first report of injury, a Shroy, it's kind of a funny word, but you'll hear it. Shroys and Shroys are the two forms that are filed. The Shroy is the first report of injury, so it's the generally, if there's an accepted claim, you'll file a Shroy 00 that will note all the pertinent claim information from the employer, carrier, third-party administrator side, and then we'll kind of lay out whether or not the claim is going to be moving forward on accepted or a controverted basis. If the claim is controverted, it would use, instead of a Shroy 00, it'd be Shroy 04, Shroy 04. That's the maintenance type code. So every Shroy or Shroy is going to have 2 digits after Shroy or Shroy that is going to indicate whether or not it's an acceptance, a denied claim, if it's a partial denial, or there's been a modification to payments that are ongoing. The maintenance type code will tell you what that Shroy is being filed in response to. Go ahead. Okay. The carrier has the obligation to file a Shroy within a certain amount of time. It's the 10 and 18 day rule. So if the claimant has an accident, you have to file a Shroy within 18 days of that accident, or 10 days from the day that you have become aware that the claimant had an accident, whichever's later. So if the claimant suffers an unwitnessed accident and doesn't tell you about it for 20 days, then you would have to file the Shroy within 10 days, so 30 days after the accident. This just gives the employers, the carriers, the insurance companies a little bit extra time if the claimant doesn't report an injury. And we see this all the time, where a claimant says that they picked up a box, strained their back, and just keeps working for 3, 4, 5 weeks, and then goes to City MD or somewhere and gets treatment and says, oh yeah, it's from that accident. And now they're filing something. Now they're placing their employer on notice. That's when the 10-day timeline would be kicked in. If you're past the time, you would still file the Shroy. So if something happens and the employer is notified, but the employer doesn't let the insurance company know or the TPA know, and you're past the deadline, you're still going to want to file those Shroys as soon as possible, and then decide whether or not you're going to be filing a Shroy. There are some things that could happen that would end up being prejudicial to your position if you're late, but always get those in as soon as you can, even if you're late. So mandatory Shroy e-filing. This is the Shroy is going to indicate whether or not there's a controversy by filing a Shroy 04, saying that you're denying the claim, saying that there's some reason why you're not accepting it and admitting liability for indemnity or medical, or it can be an indication that the claim is accepted and payments have begun on a voluntary basis, or that the claim is not controverted, but no payments have begun because it's a medical only claim, or a partial denial or something along those lines. So you can file. The important thing for this slide is to note when you're controverting a claim, when you're saying that you are not accepting it, you are not admitting liability for indemnity or medical, that needs to be filed within 25 days of a notice of indexing at the board. And this is something that should be filed with the board. The board generates the notice of indexing. Once you get that, 25 days later, you have to have filed a Froy 04 or a Shroy 04 indicating that you're controverting it. If that is not timely, you waive some of your defenses. So the main things that you're waiving is that the accident didn't occur, that there was no employer-employee relationship. The main things that you are not going to waive, and so you would still file a Froy 04 or a Shroy 04 even if you're late. You're not going to waive the late notice requirement, and you're not going to waive coverage under your policy. So you can still file those things, but make sure they get them in within the 25-day time period so that we don't have to worry about making other arguments. Also, just real quick, you're paying without prejudice. If the claimant is alleging an accident, but you don't have any medicals or anything else that would substantiate, you can pay without prejudice. Or if you are assuming that the accident happened the way that the claimant is saying, but you're still doing some investigation, you can mark your payments as without prejudice or without liability, so that you don't give up your right to further investigate the claim or controvert it down the line just because you made initial payments. So that gets us into the controversy period. Were there any questions, Jason?
Right now, we don't have any questions.
Okay.
I do encourage everyone that if you do have any questions to use the Q&A, type it in. When we switch off between Adam and I, we'll respond to any questions as they come in. What Adam just went over with everyone really focuses a lot on the process by the adjusters, the TPA, the insurance carrier. Right now, I'm going to focus on where we as attorneys start to get more involved with the claims, which is the pre-hearing conference and the pre-hearing conference statement. Most controverted claims, a denied claim, will go under this expedited hearing process, the rocket docket, where once the denial is in the board file and the first medical report is with the workers' compensation board, they're going to schedule an initial hearing or a pre-hearing conference, as they call it, where there are several rules that need to be followed. One of the most important things is the pre-hearing conference statement, the PH 16.2 form, which is due within 10 days prior to the initial pre-hearing conference. And that's not just the form. For that form, we need to include any witnesses that we may want to produce at a later trial, any exhibits. And the most important thing here is from the onset of the claim to investigate as soon as possible to obtain all that information. At the actual pre-hearing conference is when the judge will make initial determinations on medical, direct IMEs, direct witnesses to appear at a trial. But that's really the best opportunity to produce our first evidence. Now, obviously, there can be many different reasons to deny a workers' compensation claim. This slide covers some of the ones that we see more often than not. Coverage is straightforward. It's sort of what it sounds like. Does the insurance policy cover the employer, or sometimes does it cover an employee? We see unique situations with construction companies with wrap-up policies where the general contractor may be covering for a subcontractor and they may be liable. Adam and I deal with a lot of professional employer organizations where we argue that non-leased employees shouldn't necessarily be covered. That really turns into the employer-employee relationship as well. Obviously, is the person actually our employee? Now, we say, were they an independent contractor? But that doesn't mean were they W-2 or 1099. The Workers' Compensation Board won't care about that. It's a factual determination for the judge to make. So oftentimes, if an employee is a 1099 employee, they're still considered an employee for employer-employee relationship under the workers' compensation law. It's a very fact basis the judge will have to look at. employer-employee relationship defense is something that must be raised at the initial hearing. So it's something that as attorneys, we need to know about right away. There are certainly cases where the Workers' Compensation Board, which in New York is heavily claimant friendly and places the burden on carriers to disprove certain issues, will say that it wasn't raised in time and they don't care, and that carrier is liable for something that wasn't their employee. The big thing we deal with is obviously the accident itself. Whether the accident happened, whether it was exaggerated, whether it falls into the person's work. Was the person, for example, going to their car and slipped on ice? And at that point, then we need to know more facts. Was it in the parking lot controlled by the employer, or was it on a public street? And then the last thing is notice that comes up the most often. Now, you're required to give 30 days notice to your employer, but that's a very liberal statute. The board allows essentially anything to be considered notice. If Adam were to fall out of his chair right now and we all saw it, that would probably fall under notice, even if he decided for whatever reason not to tell our human resources department until the 31st day. The board would forgive that. It would be considered timely notice. It's really notice as far as the Workers' Compensation Board sees it, not notice as far as the employer necessarily sees it. Continuing on, other defenses. These are ones that become a mix of both denied claims and accepted claims. Causal relation begins with, does the claimant have what we call PFME, prima facie medical evidence, something that basically says there's an injury and that injury occurred at work, and the doctor, the claimant's treating doctor, confirms the injury was caused by the accident at work. And that can come up on a claim in general. Sometimes we'll have a claim where somebody has a pre-existing back condition and will deny the whole claim because of that, and investigate with subpoenaing earlier medical records and having an independent medical examiner and IME comment on it. Other times it shows up on an accepted claim. Claim could be accepted, for example, for a knee injury, but a claimant might allege that after 6 months of walking on crutches or walking with an altered gait, that all of a sudden their back hurts. And now it's an accepted claim, but we're still disputing whether there's causal relation for that back injury as a result of the initial work-related knee injury. And then the last primary defense that we want to discuss is the defense of unrelated wage loss. And this doesn't really fall into the category of an overall denied claim. It often comes up when we're denying claims in general. But if the only defense is the claimant stopped working for reasons completely unrelated to the claim itself should not be denied or controverted. For example, somebody hurts their knee, continues to work for a month, and then is laid off, for example, due to the pandemic. They still have an active workers' compensation claim for the knee. They're entitled to medical treatment. But we're not denying the whole claim. We can still dispute before workers' compensation law judge if the person is entitled to payments for lost time. And it follows a completely different approach. It doesn't follow the pre-hearing conference statements, the pre-hearing conferences, but the judge could still schedule a trial solely for that purpose. Started speaking by saying that a lot of what I was going to go over for this part of the presentation involved what the attorneys would do. But these defenses do need to be put on the denial forms, as Adam mentioned, the maintenance code, the 04 on the Shroy 04 or the Shroy 04. These are just some of the codes. Anybody familiar with the denial forms would know that there's probably about 20 different codes you could use. These are the ones that come up the most. The most importantly, these things do need to be raised at the first instance. So in certain circumstances, depending on what the defense is, that they don't get waived. So to just sum up, when controverting a claim, we have 6 steps here. Of course, Adam gives me the slide that has the joke at the end to contact Chartwell Law. He asked for it to be first, but we moved it to the 6th one. The most important thing here, more than anything else, is to act promptly to investigate the claim. We don't want a scenario where we go to trial 6 months after the accident maybe happened and find out video was destroyed, or some witness was let go, or somebody doesn't remember anything. The time to investigate the claim is as soon as possible after the accident to try to preserve evidence. That's true for any type of litigation, whether it's workers' compensation or general liability. But with what we're dealing with the pre-hearing conference system, we're really supposed to be producing these exhibits and these witness names no later than 10 days before that first hearing. It's important to act promptly to investigate the claim. And the next thing is to gather the necessary employer forms. We listed 2 there. The first is the C11. That just tells the board the claimant's employment status. Are they still working there? Did they stop working? Did they stop working because of the claim? The C240 is their payroll. If they're entitled to awards, the Workers' Compensation Board has to set their average weekly wage to calculate the awards. They need that, and regardless of if the claim's denied or accepted, it's a good idea to get it as soon as possible. It also gives you a good idea on exposure of a claim. If somebody has lower wages, it may not be worth it to necessarily deny a claim. You always have to have a cost-benefit analysis with any type of denied claim. Next thing is the Hipaa release. That's something we usually demand with the pre-hearing conference statement so we can obtain medical records. Not all medical records are sent into the Workers' Compensation Board. Obviously, consider obtaining an independent medical examination. Carriers are entitled to have the claimant examined by a doctor on their behalf. They don't simply need to accept claimants treating providers. Consider surveillance. Surveillance can be used for many reasons to see if the claimant's working. It can also be used to see if they're simply exaggerating their symptoms, which can be incredibly useful when we are controverting a claim. Claimant may say that they are unable to work because they can only walk 1 block before excruciating pain. But if we get surveillance of that, it can go to the credibility of the claimant, which can not only be used to help dispute the claim, but also could help with later issues if the case gets established to help reduce overall liability. Adam, do we have any questions?
Yes, 2 questions. First is, can an adjuster file the pre-hearing conference report?
We certainly see that. We usually don't recommend it, but an adjuster can file the pre-hearing conference report. Every insurance carrier is different with how they want it internally. As a practice, we generally recommend the attorneys do it. As I mentioned, it's important to have the defenses raised at the first instance. The board looks the other way a lot on the Shroy and the Shroy forms. Judges almost never look the other way on the pre-hearing conference statement. Sometimes if the wording's off, judges can be very particular about it. Carrier attorneys file these all the time. Our office files countless number of pre-hearing conference statements per week. It generally makes more sense to have the attorney file, but there's nothing preventing the adjuster from filing it.
And the second question is, we see HIPAA requests ignored for many months. What can we do to expedite those HIPAA requests?
That's interesting. So the best thing to do is always to get a direction from the judge. So we don't always get them, and sometimes we have to give a reason why we want the HIPAA request, especially if it's asking for treatment that's not entirely related to the workers' compensation claim. But if the judge directs it and the claimant fails to respond to it, they'll usually give them one more extension because, like I said, it's a claimant-friendly system. It is a system that's supposed to help out injured workers, so they're going to give them the benefit of the doubt. But the claimant fails to produce it after it's directed by the judge multiple times, we can ask for a negative inference and ask the judge to imply that certain things in those medical records would have shown things that aren't necessarily favorable to the claimant. But ultimately, I would say the most important thing is to ask for direction from the judge for the HIPAA release, but we do need a strong basis for it. The judges aren't necessarily going to just tell the claimant to sign over a HIPAA release and entitle us to all of their medical records. We do need a strong basis for it.
Okay. We have another question about Section 32s, but we're going to answer that later on in the presentation. We have one question. We get the scenario quite often. What is the specific process to handle a claim which we believe there is unrelated time loss, laid off, terminated for a reason, but we do not deny the claim itself? If we don't believe we owe temp, but the injured worker is out of work, how do we handle?
Okay, so right, so that's the issue of unrelated wage loss. It was like the last point I recommended or discussed for when like denials come in, you basically ask for a hearing for it. The claim's an established claim for the injury. You ask for a hearing. Depending on if awards are already being made, you may not be allowed to suspend. That gets a little bit too complicated for today, and Adam and I are happy to follow up with anyone on it. But if awards are formally directed, they can't be suspended without a direction from a judge. But you ask for a hearing. You tell the judge, we're raising unrelated wage loss. They'll schedule a trial. The best thing to do, though, while you're waiting for that hearing is to be prepared to schedule a trial. Have a witness name, have exhibits, time cards, anything that shows the unrelated wage loss, because ultimately the burden is on the employer or the insurance carrier to show that the individual is not working for some other reason.
Right. Okay, cool. Moving on. So now that we have accepted the claim, if we're not controverting, we're accepting, or it's been established, the judge has said the claimant had a work-related accident or occupational disease. What's covered for medical care? Pretty much anything that the claimant has treatment for in relation to the sites of injury that are accepted or established are going to be covered. Their hospital stays, MRIs, X-rays, their medications, the PT, acupuncture, chiropractic care, including one of the things that most people don't originally think about is transportation to and from. If the claimant needs special transportation to and from the doctor's visits, those will be compensable. Those will be something the insurance company has to pay for. Also, any durable medical goods, TENS units. We've seen a rash lately of people being prescribed these continuous motion rehabilitation machines for their knees and shoulders and whatnot. Dentures, glasses, all those sorts of things would be covered. I get a lot of questions from adjusters about, can we prevent the claimant? Can we tell the claimant to go to a certain doctor or not go to a certain doctor? No, unfortunately not. I'm sure that we would all love to be able to tell the claimants that they have to go to specific doctors or that they have to stay away from certain doctors for a multitude of reasons. But we can't do that. The claimant has the ability to see anybody who's licensed to practice workers' compensation, to accept workers' compensation insurance. The one thing is that the treatment has to be medically necessary and causally related to the date of accident. So we see a lot of times where doctors treat a claimant for both, a neck and back injury that happened at work, and then also treat for like a knee injury that's just something that was pre-existing, and then bill everything on the same medical report. One of the things that you should always monitor is make sure that the doctors are only billing for the causally related treatment. If the doctor starts billing for something that's not causally related, they should be submitting two separate bills, and it's not your job to go through and bifurcate their billing for you. You would just deny the whole bill. As part of the treatment, there's the medical treatment guidelines. The New York State Workers' Compensation Board has determined that there are certain courses of treatment that are regular and customary and make sense for different types of injuries. And they have published a very large document that goes into great detail what the appropriate course of treatment should be depending on the type of injury that was sustained. If the doctor wants to do something that's not part of those medical treatment guidelines, they have to say why there should be a variance. The burden is on the treating physicians to request treatment outside of the medical treatment guidelines. You'll see this is submitted on an MG-2 form. And those who are practicing, you also know that there's the C4 auth that's requesting authorization for treatment in excess of $1,000. The big difference between the two that I like to make sure is pointed out is that the C4 auth, the burden is on the insurance company to say why it shouldn't be approved. In the MG2, the burden's on the treating physician to say why it should be approved. So it's a burden shifting. So when in doubt, if a doctor requests an MG2, you can always just deny it because they haven't met their burden of proof to vary from the guidelines. They have to justify why the claimant needs something that's in excess of the MTGs. If you are going to have contrary medical evidence, have the MG2 submitted for review. There's a hierarchy of contrary medical evidence. The best thing is to have an in-person IME. The IME physically examine the claimant. The next best thing would be to have an IME who has already physically examined the claimant do a records review and comment on whether or not it's appropriate. And then the last thing is if you don't have an IME who's already treated the claimant, you can submit it for a records review or a peer review, utilization review. There's a bunch of different terms that different carriers and TPAs use to review that request. There was something on the last slide that I didn't quite cover. If the claimant does receive treatment that is in excess of the medical treatment guidelines and an MG2 hasn't been submitted, you would file an objection to that bill that was submitted and say that you're not going to pay for it because they didn't get the variance approved. There are a lot of things that are submitted by doctors on MG2s that wouldn't necessarily be something, even if it doesn't mean, it may be something that you don't think the claimant necessarily needs, but it's not something that is really going to be cost effective to fight. If the claimant's treating physician is asking for a very low number of physical therapy sessions, or an X-ray, or a round of injections that just doesn't cost that much, oftentimes it's going to be more cost effective for you to accept that request for variance, as opposed to sending it to an IME and then possibly having to send Jason or I to court to argue on your behalf of why that treatment should not be approved. But when in doubt, if they're asking for something and you're not sure whether or not, check the box to say it says denied and burden of proof not met. There is timing on the MG2s. If you're going to send it for an IME review, it has to be submitted. You have to give notice that it's going to be reviewed by an IME within 5 days of receipt of the MG2. And then you have 30 days from the date of submission to file a denial if you're going to deny it. If you're not submitting it for a peer review, you have 15 days from the date of submission to say that it's denied because the burden of proof has not been met. And if not, that requested treatment is going to be authorized by the board. There is the notice of expedited hearing. If there's an expedited hearing that is scheduled because you are denying a request for treatment, oftentimes there'll be a direction for depositions to be conducted before that hearing of the treating provider and the contrary medical opinion. Make sure you're reaching out to your defense counsel if that happens, because we're going to need to schedule those depositions as quickly as possible. Oftentimes there's a quick turnaround. I know right now scheduling depositions with treating physicians is a very lengthy process due to the pandemic and the extra restrictions on when the doctors are seeing claimants. It can take a long time to get those depots set up. So if you get a notice of a hearing that says expedited and that they're directing you to have depositions on the conflicting medical opinions, let us know as soon as possible. Okay, so if something's happening and you're wanting to object to it, there's two things that generally will happen if you receive a bill or a request for treatment. You're either going to have a C-8.1, which is the form that you would file that's legal objections to treatment or a bill. And then there's C-8.4, where you're just objecting to the valuation of the bill that's been submitted. There's two parts to a C-8.1B. That is, the first one is C-8.1A. That's an objection to treatment that is ongoing. You're refusing or denying ongoing treatment or future treatment. And then a C-8.1B is an objection to a bill for treatment. The C-8.1A has to be filed within 5 days of the termination or refusal or denial of the treatment. The C-8.1B has to be filed within 45 days of the submission of the bill. One of the big pitfalls that we see in regards to the C-8.1Bs, which we see way more Bs than As, and then the As are going away anyway. So but the Bs, oftentimes the carriers, the TPAs won't check the box that's the correct box. So we're saying we're objecting to the bill because it's in excess of the medical treatment guidelines, but that box isn't checked properly. Or we have a lot of times where the box other is checked and then it says see explanation of benefits page. But then you get to the explanation of benefits page and it's not readily apparent why that bill has been objected to. It's a practice tip. Make it clear on the C-8.1B as clear as possible what you're objecting to and why you're objecting to it. The C-8.4 is the valuation. So this happens when a claimant is, when a treating physician is billing for in excess of the fee schedule. In New York State, we have a fee schedule for different medical treatments. If they're receiving too frequent treatment, there's a bunch of different things listed on the slide. But this is just the valuation of a bill. You're not saying that the bill shouldn't be paid because it's not causally related or it's treatment in excess of the medical treatment guidelines or something. You're just objecting to the valuation. All right. And then timing of awards. Once the claim has been established or accepted, awards are generally only due for injuries that result in a loss of work of greater than 7 days. So if the claimant only misses 4 days, you don't have to pay them for that. Once the claimant misses more than a week, you have to start picking up payments. You can pay voluntarily without a court order. If the payments are voluntary, you can reduce them after an IME, or for some other reason, if you're claiming that there's now unrelated wage loss or something. However, the court has directed an award, you can't suspend without having the judge say that you can suspend. The medical evidence is required. The claimant is required to submit evidence of an ongoing degree of disability every 90 days. That's relaxed during COVID, but generally has to go every 3 months to their doctor and have the doctor say that they have some degree of disability. At the beginning of an accepted claim, if the claimant has a hospital report, generally the judges will accept that as evidence of a total degree of disability. But if there's some other doctor that says less than that, then that will be used to justify awards. Okay, questions?
Okay, so that covers a lot of the medical issues. We did receive a lot of questions. I guess medical costs go up, so there's lots of questions about it. First question, Adam, is transportation just mileage and or public transportation costs, or does the insurer have to provide a car service or an ambulette or an ambulance service?
So the insurance company doesn't have to provide a car service or a ambulance. If the claimant has mileage, they use a personal vehicle, they will charge in the mileage. If they have a specific expense, a car service, they would submit that receipt and that would be compensable. I would generally review those because if it's in excess, if the claimant's taking a limousine, you wouldn't have to pay for the limousine. So make sure that it's appropriate and reasonable.
Okay, this one's interesting. Is employer required to pay the claimant for the time it takes to go to the doctor visit related to the injury? I guess is it time for like indemnity or I'm not sure, but
so
general employers would have to give claimants time off to attend doctor's appointments, but that alone wouldn't be sufficient for like indemnity awards or something if they're working.
Correct. Yeah. So if the claimant goes to the doctor, the employer could make that PTO, paid time off, or they could be sick leave or whatever. But that's not going to be something the insurance company would pay as indemnity for lost time.
Okay. And if a claimant doesn't agree to certain treatment, do they lose workers' compensation, or what happens if they seek some type of alternative treatment?
So no, they don't lose their workers' compensation because they don't want to go through. Like if a doctor recommends surgery and they don't want to go through the surgery, that doesn't mean that they're losing their comp benefits. They still have the right to choose their course of treatment.
Okay. And has the board taken a position on the use of medical marijuana for accepted or established injuries? I think we have a very long memo internally on this.
Yeah, we have a long memo and it's very complicated. So generally speaking, the board is marijuana friendly, but the feds continue to not be. So I would recommend if you have questions about medical marijuana that you go to one of our publications specifically on that topic. It'll be a little bit too in depth for this forum.
Okay. This is sort of bouncing back to something you were talking about earlier, Adam, but what if initial indemnity payments were made with the Shroy IP, but later the claim becomes controverted with the Shroy 04?
Then you can cease the initial payments. If you initially pay and then you come to find out that you see a video that shows that the claimant fell down on purpose or something like that happened, then you can suspend the initial payments as long as they weren't directed by a judge.
Right. It obviously would matter if the case is established at that point. There would be other questions that come in. But in general, if there's a Shroy IP filed and awards have been made, but there's not necessarily, and this is getting a bit too complicated, but a notice of indexing or something like that, then it could usually be converted to a denied claim. We see that all the time. Cases get paid and then something comes up, someone reports something that seems off and the case gets converted to a denial. We do have a lot of questions right now on these issues, but we'll do one more and then we'll move on.
Okay.
Basically, what should we do? What do you recommend if somebody's getting an excessive amount of physical therapy or treatment?
If you're getting excessive amount of physical therapy, they're probably in excess of the MTGs. Start denying bills and saying that it's in excess without securing a variance. That's the easiest way. As soon as you stop paying bills, generally the treating physicians start wondering whether they should keep treating the claimants.
Okay, so I'll take it from here. So this slide right now, it just shows the maximum awards. It's based on the average weekly wage for the state. It goes up every year. Right now, any accidents after July 1st, 2020, the max award would be $966.78. Generally speaking, person's award is no more than 2/3 of their own average weekly wage, but these are the caps on it. So if somebody has higher average weekly wage, they're not going to get more than $966.78 on a workers' compensation claim per week. But the max could also be less if we're working with an already low average weekly wage. Adam already talked about this at length at the beginning, but turning back to some of the timeliness of those Shroy filings, the board does have penalties involved for not adhering to their requirements in the statute. A late Shroy is a $50 penalty. It doesn't seem like much, but the board does keep track of all carriers and third-party administrators and how often they're responsible for these types of penalties. So it is very important to be filing these things on time. But as Adam mentioned, if it's late, it should still absolutely be filed. I'm going to go towards the bottom of the slide here because, like I said, a lot of this was already covered. One of the biggest penalties that we want to look out for as your attorneys on a workers' compensation claim is against a late payment. The board is going to assess a $300 penalty for a late payment, but they're also going to assess a 20% interest for anything late due to the claimant. So if you're late on a $1,000 payment, it's $200 to the claimant, which again doesn't seem like all that much. Bigger concern is, what if there's a large settlement for $100,000 and it's late? All of a sudden you owe another $20,000 in the claim payable to the claimant. And then the complicated thing can be payments of installments of awards. So the statutory framework is the awards become due 25 days after they're due. So they're bi-weekly payments, just like most of us receive our salary. Every company does differently, but most companies do paychecks every 2 weeks. At the end of that 2 weeks, you have 25 days to pay. It's a substantial amount of time to pay ongoing awards, which is why we don't often see late payments raised by claimants counsel, but it can come up. And if it's late payments over a year or 2 year period that weren't caught, it could result in a substantial penalty, that 20% payable to the claimant. So our general advice there is simply don't delay payment to the claimant. Don't wait until that 25th day after the 2 weeks. Just pay promptly. Early payments on a weekly basis, when you're dealing with a maximum of $966.78 per week, they should be paid as soon as possible to avoid any types of issues. And now we've discussed denied claims and briefly touched on accepted claims. These are ways to limit liability on a workers' compensation claim that's really, at this point, accepted or established. The two big defenses we see are labor market attachment in section 114A, which is the fraud statute. Labor market attachment basically requires a partially disabled claimant to look for a new job within their restrictions. Section 114A is fraud. The next slide goes into more detail on labor market attachment. There are certain requirements for labor market attachment. One thing that's not listed here, obviously, is how this defense is being handled with the current New York state of emergency and the COVID-19 pandemic. If you were to have a claimant who's no longer an employee of the insured or the employer of record, and a formal finding that they have a partial disability, normally would tell the judge, we're raising labor market attachment, and the judge would say, okay, come back in 60 days with proof that you've looked for on a diligent search for a new job in order to maintain your workers' compensation awards. Unfortunately, it's now been a year since the beginning of the pandemic, and around late March 2020, the Workers' Compensation Board simply issued a notice. It's not statutory or anything like that, and it is on appeal by, I believe, several carrier firms, that judges should not direct labor market attachment due to the pandemic until the state of emergency is lifted. We're all obviously optimistic that the state of emergency will be lifted in the next few months, but that optimism has been going on for a while now. In short, the judges aren't allowing this defense right now because of the pandemic, so we have to look for other options. One is, what if the claimant is still employed with the employer of record or insured, which is you can make a light duty job offer. If it's pursuant to restrictions set by either the board or the claimant's own doctor, and the claimant ignores it or is unreasonable about it, the judge will consider suspending their awards. The other thing is, and I know Adam deals with one client who handles this type of situation, is there's now starting to be outside programs that help claimants try to find new jobs. It's unclear how the board is going to adhere to those because it's still the defense of labor market attachment. But at this time, it's important to get creative with this type of defense because we essentially haven't been able to use it for the last year. And a practice point, as of April 2017, when a claimant is found to have a permanent disability, even if it's a permanent partial disability, the Workers' Compensation Board essentially says that's the last time to raise labor market attachment. If a claimant is found to be attached to the labor market, meaning that they were doing a due diligence around the time they were found to have a permanent impairment and looking for work then, they're entitled to ongoing awards then, and the carrier cannot raise it again, which of course then is delaying permanency findings, since in general, carriers are not willing to waive this type of defense since it can significantly decrease liability on a claim. Turning to 114A, that's the fraud statute of the Workers' Compensation Board. It requires a claimant to knowingly misrepresent something to the Workers' Compensation Board. Generally speaking, there are things that are found on surveillance video of claimants either working when they've said they aren't working, or a claimant simply exaggerating symptoms, and it's shown on video. Somebody says, as I said at the beginning of the presentation, can't walk more than 1 block, but then you find them playing in a semi-pro basketball league, which is an exact case I've dealt with before. But there's other ways that 114A can come up. It doesn't always come up in surveillance video. And for that reason, we recommend that outside private investigators monitor Facebook, social media, and also do searches for business records. Oftentimes, claimant may establish a business while they're out on workers' compensation. There will be public records, and it's another example of something that we've seen in our office.
Okay.
Any questions?
Yeah. So just a couple. What can be done when the provider won't provide any work status so the claimant may return to light duty?
Interesting. So I think that's asking if the claimant already has a temporary partial disability. And that comes up a lot because the judges won't say claimant has a partial disability and here are the restrictions. The judge is just going to say there's a partial disability. Usually at that point, we just say, use the restrictions from the IME, let the claimant has an obligation to respond to any type of light duty offer when there's a partial disability. And then the judge, it's fact-based, the judge will look at how reasonable it is. Sometimes the judges will direct a doctor to go ahead and give restrictions as well. Okay.
I'll note there was a question about payer compliance hitting the standard. To be honest with you, I'm not really sure whether or not I haven't been hearing lately that the clients have been complaining about not hitting their payer compliance, but that's a little bit outside of the scope of this presentation. And then there was a question about sick time vacation. that's going to come into employer reimbursement. And it is, again, a little bit more of a complicated question to go into with the time that we have today. For you, Jason, can the labor market to attachment be relitigated if there's an evidence of a change in medical condition?
Yeah, I don't see why not. I mean, it can be really raised at any time as long as the claimant doesn't have a permanent disability. If it's a changed medical condition after permanency, it's probably a fairly complicated question. We had case law that came out at the beginning of the year that kind of flipped that on its head. So my hunch would say, yes, go for it. I mean, the worst case, the judge says no in that circumstance. But if there's a change in medical condition where the claimant's condition gets better, then absolutely. If it gets worse, that's also interesting because there's case law that says if a claimant has a partial disability and then attachment's raised, and then they have surgery, which would then immediately render them totally disabled as a presumption, they were still required to look for work up until the date of that surgery.
Okay, cool. All right, I'm gonna jump in and start moving things along. I know that we've only got about 10 minutes left, so trying to get through the last little bit here. So once we've litigated and we come to the end of a case, the three ways that a case ends mainly is a schedule loss of use, which is when the claimant has a permanent impairment to an extremity of some sort. You can have a classification, which means the claimant has a loss of wage earning capacity, usually for head, neck, and back injuries. Or we have a Section 32, which is, in our opinion, the best way to close any of these cases. The Section 32 is a settlement agreement. So moving on to the next slide, maximum medical improvement. In order to reach permanency and have a SLU or a classification, there has to be a finding the claimant is at maximum medical improvement. Just means that they're as good as they're going to get under standard course of treatment under workers' comp. It doesn't mean that there can't be palliative and ongoing care. They still would be entitled to some medical treatment, but it's not going to be the same type of treatment. It's going to be very limited. The important thing is that it's generally maximum medical improvement is not going to be found until at least 6 months after an accident that doesn't involve surgery or fractures. If there's a fracture involved, generally speaking, we're going to be looking at about a year. And then if there's surgery, we're going to be looking at 6 months to a year after the last surgery, depending on what type of surgery we're talking about. Going into the schedule loss of use, again, it's how much loss do you have of an extremity? So this is all generally done using range of motion testing. So if my arm, I can only raise my arm up to my shoulder height at some point after all of my treatment, after I've been found to be at MMI, that's going to be a certain percentage loss of my arm. It seems a little morbid, but like you're compensated for the loss of your arm. The important thing to remember is that it's not a specific like a loss of arm for all of your life. It's a wage replacement scheme. So because I have a loss of use of my arm, that has an impact on my wage earning capacity going down the line. And because of that, I get an award for that loss. So it's not pain and suffering. It's not discomfort. It's not because I can't tuck my shirt in. It's because it's an indemnity replacement. There was a question, and I'm going to answer just right now in line about the MMI. Once you're found to be at MMI, if the claimant's treating physicians keep treating, then you would object to those bills. If the board is finding those bills in favor of the providers, I would object to the proposed decision, finding that in favor of the providers, and ask for a hearing and say, look, the claimant has been found to be at MMI and they're still treating. These should all be found for the carrier. This is just a slide that covers the number of weeks given for each. It's, again, I find it incredibly morbid. As somebody who's worked, I used to drive a forklift, and like I was in constant danger of being impaled on something or crushing my arm. It's weird to see it listed the number of weeks that my arm or hand would have been worth, but that's just the way that we do it here in New York. One of the things to remember when we're talking about schedule loss of use is that anytime the claimant is running at temp total benefits, they can accrue protracted healing period. So it's important when we're dealing with an arm, leg, hand, foot case to have IMEs that are going to find that the claimant is less than totally disabled as soon as possible so that we can cease those temporary total benefits, have them run at a temporary rate or a temporary partial rate and avoid PHP. Once the claimant reaches a certain number of weeks, depending on the body part involved, so for an arm, it's 32 weeks. After 32 weeks of temp total, they're going to get an extra week of valuation on that SLU, basically, at the end of the day. So you're basically paying double if you're continuing to pay temp total after the protracted healing period for that body part. When the claim closes on a scheduled loss of use, you get credit for any prior payments. Facial awards are a little bit funny, but we can go into that in detail if there's questions. The other way that you close a case with a permanent impairment is a permanent partial disability classification. This is where we have the loss of wage earning capacity. The claimant is determined to have a permanent impairment based on their injuries, and that it has reduced their ability to earn income by a certain percentage. The things that are taken into account with that is the actual medical impairment, residual functions, function limitations, and their vocational factors. This is where we get into the weird case of, at the end of the day, when we're arguing for doing a loss of wage earning capacity trial, we're arguing the claimant is a superhuman and is super smart and capable of doing all these other things and isn't that badly hurt. Whereas the claimant's counsel is saying the claimant is incapable of learning anything else ever again, is basically non-functioning, and is never going to be able to go back to work again. When making the arguments, we go into the impairment tables. So anytime the claimant has a neck or back, or the things we see most often, you'll have an impairment rating given by the treating physician and the IMEs. The higher the letter, the more serious the permanent impairment. But they don't necessarily, they're not one-to-one across body parts. So a G severity ranking for the back is not the same as a G severity ranking for the head or the lungs. So it's just, you would just look within each body part to kind of figure out what the total impairment is going to be for those permanent partial disability classifications. Once the claimant is found to have an LWIC percentage, after March 2007, you have a cap. You have a certain number of weeks based on the percentage loss of wage earning capacity. The higher the loss of wage earning capacity, the higher percentage of their average weekly wage they get, and the more number of weeks they get. The important thing that we always try to focus on is when we're classifying claimants, particularly if there's a serious injury, we're always trying to get less than 75%, because if it's more than 75%, the claimant could then come back and argue for a hardship reopening, and we don't want to have that. It just causes a lot more problems down the line. So we're trying to keep it below 75. We can go into extreme hardship. It's kind of complicated. We don't see it that often. I wouldn't worry about it too much for this purposes. And then there's the note, there's a cap on the disability benefits. At this point, 2.5 years after the date of accident, if it happened after April 10th of 2017, the carriers will be able to take credit against future PPD benefits for temporary partial benefits in some cases that are more than 130 weeks post-accident. I think we already covered the loss of wage earning capacity, the multitude of factors. The one thing that I do want to point out, if we have any LWIC trial and you have access to the claimant's application or their initial job employment forms, their resume, those sorts of things, those can be helpful to defense counsel. That's something that a lot of people don't think about. So forward that to us and we can review those. That'll help us when we're making the arguments about the claimant's vocational capabilities. Treatment after MMI, we get 10 visits of chiropractic, physical therapy, or acupuncture. If there's no variance from the medical treatment guidelines, so they have to ask for a change in condition. I think we kind of covered that. The important thing is they only get 10 visits per year. All right, and then we move on to, Jason's going to cover settlements quickly.
Right, so we're coming right up on the hour mark. We did get some questions, but I looked at them and I think I'm going to cover them right now. The Section 32 settlement is really the ultimate closer on any workers' compensation claim. What Adam just discussed, the scheduled loss of use and the classification, those are permanency findings. And it reaches the point where we're basically done with as much as possible on the workers' compensation claim, but the claim still exists. It could pop up a year later, it can pop up 20 years later, and we've certainly seen A couple weeks ago, I handled a claim from 1999. The only way to truly close out a workers' compensation claim so it never comes back again is a Section 32 settlement. It's the statutory framework where the board allows simply a negotiated number, carrier pays the claimant X amount, claimant closes out the workers' compensation claim almost as if it never existed. It could be just for the indemnity and keeping the medical component open. We usually don't recommend keeping the medical open, but circumstances do come up. Somebody asked at the beginning of the presentation when we would consider a Section 32 settlement. Typically, we like to do it around the time of permanency. That's the best way to value a Section 32 agreement. But every case is different, and there's certainly examples where, especially on denied claims, where both Adam and I and everyone else on our team have looked at where we anticipate the value of the claim will be and see if the claimant's interested in an early Section 32 agreement. Just one thing, and this is, I think, addressing another question that comes up far too often, is if there's a third-party accident or a third-party claim. Adam mentioned, a motor vehicle accident, you would sue the driver of the other vehicle, or in the construction scenario, general liability claim where you file a suit against the building owner and the general contractor. And claimants usually represented by two different attorneys, one for workers' compensation, one for personal injury. Personal injury attorney is usually not too eager to ultimately close out the claim with a Section 32 agreement because they want to make sure their client's still getting treatment while they're pursuing a third-party action. And carriers, third-party administrator employers, they have liens on the third-party action, so they will get money back. But at the same time, they do want to limit liability as early as possible. But one of the worst scenarios we can fall into is we negotiate a Section 32 agreement with a workers' compensation attorney. It's completely fair for everyone. And then we find out the third-party attorney just said, nope, not happening. And then we're just back to square one wherever we were with the claim. Just a final thing to go over with the Section 32 agreement is Medicare's interest with it. In general, all Section 32 agreements that close up the medical component should include a Medicare set-aside and MSA. Medicare obviously does not want claimants, workers' compensation claimants, and this comes up in other fields as well, settling out their claims, the medical coverage, and then expecting them to be liable for further medical costs. Medicare requires CMS approval in certain circumstances. It's here on the slide. If the claimant is actually on Medicare and the total settlement is greater than $25,000, the MSA included in the Section 32 agreement must be approved by CMS. That could take several months. Usually a third-party vendor, some IME companies do it, calculate a proposed MSA. It goes to CMS, and they either say they agree or disagree with it, and then if they disagree with it, they propose a new number, and that number must be in the Section 32 agreement to be approved. If they're Medicare eligible within 30 months, so they're not necessarily on Medicare yet, the threshold is much higher, it's $250,000. But in general, all Section 32 settlement agreements must include an MSA. The question is whether it includes an MSA that's formally calculated and approved by CMS, or if it's just a number the claimant's agreeing to set aside. But once the Section 32 settlement is approved and done with, it's with the claimant. The claimant has the money, the case is closed, and it's up to them to administer the MSA at that point. The carrier is no longer paying any type of medical costs or doctor's bills. Anything like that comes in, you advise the doctor that the case is settled and the claimant's responsible for them. And then if you have any questions, we're about at the hour mark. Our contact information is here. Adam's and my direct phone numbers. We have a general email, nyhearings@chartwelllaw.com. If for any reason you can't get in touch with us, but really shouldn't be a problem. This was a presentation obviously on New York, but we do have offices now up and down the East Coast that primarily focus on workers' compensation and general liability. And if you have any questions, feel free to reach out.
All right. And again, want to thank you all for being here. This was a lot of fun, strangely. So Jason and I enjoyed talking about these sorts of things. There were a couple of questions, but again, we would encourage you to reach out to us directly just so we don't hold everybody up today. So thanks again, and we'll see everyone soon.